Hello and welcome to the latest of the Dehns webinars. I'm Chris Goddard and I would like to talk to you today about the Supplementary Protection Certificate system in Europe. This in fact is the second part of a two-part series on this topic. So if you did miss the first part and you want to catch up, the video for that should be available on the Dehns website at www.dehns.com under the Inspired Thinking section. So do feel free to watch that and come back if you wish. I'm Chris Goddard. We looked at my biography last time, but essentially I've been a partner at Dehns for about 7 years now. I joined just over 20 years ago, and I've spent most of that time working on pharmaceutical, medical, diagnostic types of inventions. So today's webinar should take perhaps 30-35 minutes, something like that, and there is the opportunity to ask questions at the end if you would like to do that. There should be a Q&A box that you should be able to find through Zoom. Do feel free to put questions into that at any time, but I will answer them all at the end. So please don't feel I'm ignoring you if you ask a question. I don't get to it straight away. If you have a sort of more specific case-related type of question, do feel free to email me. My email address will be at the end. It's very easy. It's cgoddard@dehns.com. I know some of the subjects of this webinar may be a bit intricate, so do feel free to email me if you would like to do that. So today, as I say, this is the second part of our talks on SPCs, and so I will just do a very brief recap of what we looked at last time. Do feel free, as I say, to go back and watch that video if you would like to. Having looked at that, we'll then review again some of the key articles of the SPC regulation, and in particular those that will feature in the cases that we will look at. And then we'll have a look at some of the recent CJEU cases. Now, my hope with this is to look at these from the point of view of what we can practically do and take from these, rather than necessarily as a sort of patent attorney's CPD theoretical talk. And so to the extent that we can tie these into actual real practice and what we might want to do about them, then we'll try to do that. So the first thing we'll look at is the question of medicinal products under Article 1, and which things we can protect, which things seem pretty clear we can't. Then there's the term protected by the basic patent, which has been subject to quite a lot of cases over the last few years. We'll have a quick look at that and give us an idea of which patents we're likely to want to choose to try and apply for our SPCs for, if we have a choice. There's then the question under, again, Article 3, Article 3D of what is the first marketing authorization. And that leads on to the question of whether we can use second medical use claims as the basis for an SPC, and under what circumstances. So we'll have a look at that. And then that kind of leads on to a quick diversion into the pending Novartis case. And then finally, one or two possible issues that might be of contention in the future, and possible issue of the question of how one defines the scope of protection for an SPC, and whether that could be a trap in the future that we should look to avoid. So, starting off with a very quick recap of what we looked at last time, an SPC is a patent term restoration right. It's similar to patent term extensions in the US and similar sorts of rights in a number of countries. It's there as a sort of compensation for the fact that patent term will inevitably be lost in getting marketing authorization for certain products that require regulatory approval. It applies to pharmaceutical products, including veterinary products, but it also does apply to plant protection products. And the two regulations that are relevant are at the bottom of your screen there. I will send around a number of links after this talk, but those two regulations really do correspond pretty much article to article as far as they realistically can. So I will look at the pharmaceutical side because that's where I have worked, but much of what I will talk about today applies equally to plant protection rights. SPCs are an independent right. They're not a patent term extension. They're a sui generis independent right that takes effect immediately on expiry of the original patent. And that does mean that they have a different scope of protection to the patent, and it's a more limited scope. It's limited essentially by both the patent and by the marketing authorization, and covers pretty much the overlap between those two. And from a practical point of view, we have a 6-month window to apply for our SPC, and that 6 months begins at the later of either marketing authorization grant or patent grant. So if your marketing authorization is first, you have 6 months from grant of the patent. If your patent is granted earlier, then you have 6 months from marketing authorization. And so, as I did say last time, if your external patent attorneys are involved in grant of your patents, please keep them up to date with the grant of your marketing authorizations, because that might control when they need to be applying for the SPCs. SPCs can provide up to 5 years of extra protection on top of what remains of the patent protection, with the idea being to top that patent protection up to 15 years. So you can have a maximum of 15 years combined protection between patent term and SPC term, counting from the grant of the marketing authorization. If you have marketing authorization plus 10, 11, 12 years, then the SPC term will be reduced. If you have a shorter term of patent protection remaining, say 12 years, then your SPC will top it up by another 5. And sorry, if you have less than 10 remaining, so if you have 8 years, for example, that will top it up by another 5 to give you 30. The key parts of the SPC regulation that we're looking at here, well, Article 1 will particularly look at the question of what is a product, and the key thing to remember with Article 1 is that the product is not the thing you sell. The product is the active ingredient or the combination of active ingredients. We'll also look briefly at 1A, which is the question of a medicinal product and what that is and isn't. Article 1C also gives us a key definition that we'll look at, and that is the basic patent. So the term basic patent is used throughout the regulation, and obviously I will use that term today. That term essentially means the patent that we are trying to extend with our SPC. We'll also look at Article 3C, well, 3C and 3D, in fact. Article 3C will touch on briefly the question of whether there's been a previous SPC, and there are several cases recently that have come out on Article 3D, the question of whether the marketing authorization referred to in the SPC application is the first authorization for the product being the active agent. So we will look particularly at Article 3D and briefly at 3C. Then finally, there's the question of the scope of protection. As I say, Article 4 talks about the protection conferred and the fact that it's limited by the basic patent and also the product covered by the marketing authorization, so kind of the overlap between those two. And Article 5 says that the certificate confers, so the certificate being the SPC, confers the same rights and limitations as the basic patent. However, and I did touch on this briefly in the questions last time, but I thought we should put this together slightly more formally. Article 5 of the SPC regulation was recently limited by a manufacturing waiver, which essentially says for the period of the SPC, there is a cutout where the patent would have given you protection that the SPC doesn't. And that's particularly for making the product, which is the active agent, or a medicinal product, corresponding medicinal product for export. And the idea behind this is that there are countries where patent expiry is the end, there's no patent term extension or SPC, and in those countries, generic manufacturers will have an advantage because they'll be able to manufacture and sell in those countries without limitation by an SPC. So the idea of the manufacturing waiver is to try to help generic manufacturers in the European Union be on a closer to level playing field, because they can manufacture in the EU, but they have to export to a country where the product can be sold. So making of the product or importing the active agent for making into the medicinal product and strictly necessary acts involved in that are permitted providing the product is strictly for export. One can also make the product and store it during the last 6 months of the SPC term. And that again is to help generic manufacturers in order for them to essentially be ready to market once the SPC expires. So again, that's kind of balancing things up where a foreign manufacturer could make the product somewhere where there isn't an SPC and then could immediately have it on the European market the day that the SPC expires. This allows European generics manufacturers to be in a similar position, to have the product ready to sell, but the market doesn't open up to actually sell it until the expiry of the SPC. They can make and store it and do necessary acts for that. And there are a few limitations in terms of what can be done. So you can't simply import the product, repackage it, re-export it, or anything like that. It can't simply be for storing it, except in this last 6 month period. It has to be for manufacture, either of the active or a medicinal product. There are certain documentary requirements. You have to market for export. You have to inform the SPC holder of what you're going to be doing. So moving on to some of the cases, the first one I would like to look at is Boston Scientific case. And that relates to the question of what is a medicinal product, Article 1A. And Boston Scientific had created a stent and coated it in paclitaxel. So there's no question that paclitaxel is an active pharmaceutical agent. And they applied for a CE certificate of conformity and then applied to the German Patent and Trademark Office for a corresponding SPC, saying that this CE mark was equivalent to requesting marketing authorization, and so they required authorization in order to market this, and so they should be entitled to an SPC. So the German Patent and Trademark Office rejected this, and it was appealed up to the CJEU. But the CJEU reasoned that the SPC regulation is limited strictly to medicinal products, and medicinal products have a different action, a different regulatory system in comparison with medical devices. And so the fact that paclitaxel was present didn't alter the fact that this was fundamentally a medical device, and that SPC regulation didn't apply to medical devices, irrespective of whether time was spent achieving a CE certificate or similar. So, so medicinal products, yes. Medical devices, it appears that we are not able to apply for SPCs to protect codes. The second case, again on Article 1, is the question of what constitutes the product, the active agent in this case. And we'll remember the product can be an active agent or a combination of. And so GSK had a new vaccine adjuvant. This is called AS03. And they applied for 2 UK SPCs, one to the adjuvant itself and one to an influenza vaccine, which was a combination of an influenza antigen and the adjuvant in addition. And the UK rejected both of these on the basis that the adjuvant could not be considered to be a product. So there was no product in the first case and there was no combination product in the second, because the adjuvant had no independent effect. So in the earlier MIT case, which is also listed on the screen, a similar decision was come to with the question of an erodible matrix, which was considered not to have an independent activity of its own. And so UK IPO took a similar view on this and said vaccine adjuvant has no independent pharmaceutical action. It can't be seen as a product according to the SPC regulation. This was then appealed to the High Court, but the CJEU and then eventually to the CJEU, who upheld the narrow interpretation of 1B, Article 1B from the MIT case, and said no, the adjuvant has no has no independent therapeutic effect of its own. It's enhancing the therapeutic effect of the influenza antigen, and that wasn't contested, but it couldn't be the subject of an SPC because it wasn't an active agent in its own right. So, moving on to Article 3, we have quite a few cases over the years on the question of what does it mean to be protected by the basic patent? As we said last time, that doesn't simply mean falling within the scope of the claims, as one might imagine from knowledge of patents and so forth. You might think if as a product on the market it would infringe the claims, then perhaps that's protected by the patent, but not according to the SPC regulation. So some of the fairly recent cases in Medivh, for example, said that the product should be specified within the wording of the claims, and Eli Lilly allowed the possibility of functional wording, but the claims needed to relate implicitly, but necessarily and specifically to the active agent in question. So there were a number of cases on this, quite a lot of divergence, quite a lot of uncertainty, different practice in different jurisdictions. So we have had a couple of recent cases in TEVA and in Royalty Pharma / Sandoz, and those hopefully will give us a bit more of an idea of where the land lies on this. So looking at the TEVA case initially, this was a situation of multiple active agents with a litigation between TEVA and Gilead. So Gilead owned the SPC for a combination of two reverse transcriptase inhibitors for HIV treatment, and the TEVA challenged the validity of this SPC on the basis that this was not considered to be protected by the basic patent in force, and that was referred ultimately up to the CJEU. So the CJEU looked at this and said, well, we need here a two-stage test. And one of the key things to consider in this is the fact that TEVA is taking us much more towards a whole content view of the basic patent, the patent that we're trying to extend with our SPC, where the earlier cases were concentrating much more on the claims. So here we have a two-step test, and we need to satisfy both of these. So the combination of active agents, because TEVA was looking at a combination, needs to be necessarily, in light of the descriptions and drawings of the patent, to be falling under the invention covered by that patent. And then secondly, each of the active ingredients must be specifically identifiable in light of all of the information in the patent. So here we still have to be able to identify the active agents, but these are identified in the information disclosed in the patent as a whole. But we do also have the requirement that the invention needs to come into this as well. So there have been previous cases which have been saying, well, the combination, it's not just enough to disclose the two agents separately, you need to disclose the combination. And this appears to be being upheld by TEVA, where we're talking about the combination being part of the invention rather than simply each of the active agents being there. And yes, particularly, we potentially allow for the combination not to be expressly mentioned in the claims, but we will require it in the description. Royalty Pharma and Sandoz was interesting because that then expands this somewhat further. They are two independent references, but they were joined as a single CJEU case. The first reference in Royalty Pharma was referred up from the German Federal Patents Court and related to an anti-type 2 diabetes medication, this sitagliptin, and that was developed under license from Royalty Pharma. And initially the German Patent Office refused the SPC on the basis of the functional language involved in the claims of the patent. There was no specific disclosure of sitagliptin. I think that was accepted by all parties, and so this refusal was then referred up to CJEU for consideration in view of the varying case law that we have had. An almost corresponding issue came in the Sandoz case, where this was a referral from the UK Court of Appeal, again relating to HIV. This was a HIV protease inhibitor. And in this case, this was the SPC validity being challenged in litigation. And the situation in this case was that the SPC was based on a patent which defines the active agent in terms of what's called Marcouche language. I imagine most of you are aware, but just in case anyone is not, a Marcouche formula is generally where there's a central core of common structure, which is usually defined by its structural formula drawn out in the patent somewhere, with a number of groups usually referred to as R groups, just general substituents, which are positioned at specific points around that structural core. And each of those R groups is generally chosen from a limited specified group of options. So that allows potentially a permutative combination of structures where the idea is that the core specified structure should control the key properties and allow the discovery of that structure or the establishment of that structure to give potential protection for a number of variants specified by more or less trivial groups around the core. But it was again accepted that the actual specific structure of this darunavir, the HIV protease inhibitor in question, was not set out with each of those groups specified in the original patent. So royalty pharma, we have the full judgment on, and there was much argument in the earlier stages of this relating to whether the test should be for the core of the inventive advance, in which case the functional language should have been fine, because really in this case the core inventive advance was the idea that type 2 diabetes could be addressed by compounds of this general nature, general function. However, the CJEU in this case referred back to TEVA and said, no, the TEVA two-stage test applies, in this case a single active agent rather than both, but we still need the two steps. We still need to fall under the invention, and the compound still needs to be specifically identifiable. And they indicated that that should be at the filing date of the patent, or at the priority date of the patent. And in fact, the specific compound in this case was only really developed after the patent was filed. And so it was considered that that was not appropriate. The functional definition in this case was not sufficient, but that functional definition shouldn't be precluded, providing the TEVA two-stage test applied. So clearly, the level by which the functional definition can contribute to the claim may be somewhat limited, because it will be necessary to specifically identify the active agent. So it could perhaps be a situation where an active agent was previously known, perhaps for another indication, would have been widely known in the common general knowledge as having the function required, then perhaps that might be considered specifically identifiable at the priority date. And so that might satisfy the TEVA two-stage test. Obviously, there's a risk with that situation that it may have been subject to an earlier marketing authorization and so forth, so the SPC still might not be possible. But that's the kind of situation where a functional language might be allowable in the SPC application, or in the patent, basic patent from which the SPC application will be derived. The Sandoz case, unfortunately, although it was joined with royalty pharma, was then withdrawn before the final judgment. However, and I should take half a step back here and say that for anyone who isn't aware of the way in which CJEU judgments are laid down, there's a sort of two-step judgment produced by the CJEU. Initially, there's an advocate general who's a single nominated lawyer who looks through all the arguments that have been submitted and comes up with an opinion, what's essentially a recommendation, boils down everything that has been sent in, and gives his or her opinion as to what they consider the legal position to be. The court then produces a judgment, and sometimes that corresponds very closely to the Advocate General's opinion, sometimes it completely overturns that opinion. So in this case, the Sandoz case got as far as the Advocate General's opinion, and that was very much very similar to the opinion and in fact the final judgment in Royalty Pharma. It essentially said, fine, you can use Marcus language or Marcus definitions, but the two-stage TEVA test still applies. We don't have the final judgment to support that, but there's no reason, perhaps since the final judgment of the court supported the Advocate General in the Royalty Pharma side, there seems no reason why one shouldn't assume that it will also support the Advocate General's position on the Sandoz side. So we don't know for certain, but it's a reasonable expectation that Marcus formulae again would be fine, but still providing that that specific compound can be specifically identified. And so we don't really know how general the Marcus formula could be in order to allow for that. I think in the Sandoz case, there were something like 10 to the 100 or 10 to the 300 or something compounds potentially encompassed by the Marcus formula. So whether that would be considered to be specifically identifying any individual compound, that's perhaps questionable, but as I say, we don't have any definitive information on that. But there is at least a suggestion that Marcus formula should not be rejected out of hand. And so that we have at the bottom, but we still need some additional guidance on some of these key issues, particularly what do we mean by specifically identifiable, especially in the context of functional definitions or Marcus language. And, you know, how do we know for, you know, how specific do we need to be to say that something falls under the invention? But at least we get a reasonable indication now that we're talking about the whole contents of the patent rather than specifically the claims, and that perhaps gives us an idea of where we should be concentrating our prosecution practice, that perhaps we're looking more at the drafting end, and perhaps we can fix that less during prosecution by moving things into the claims and so forth. So moving on to Article 3D, this, as we have seen, says that the marketing authorization that we rely on for our SPC should be the first marketing authorization to place the product on the market as a medicinal product. So for background to this, we need to go back to a judgment in summer 2012, I think this was, under the Neuron case. And I won't go into detail on this because, as you will see, it's probably not that relevant now, but we do sort of need it for background. Neuron related to a situation where there were two marketing authorizations. The first one from some years back had been for the treatment of infertility in sheep using the hormone melatonin. So that had been known and marketed, and a marketing authorization was present for that. Neuron developed a new use of melatonin, which was in humans for treatment of insomnia. And the judgment in the Neuron case essentially said that we can treat this new marketing authorization as the first marketing authorization for melatonin according to Article 3D. And we could do that according to Neuron because we could ignore an earlier marketing authorization which authorized a product which fell outside the scope of the new patent. So we had a first patent and a first marketing authorization, and the first product was within that first marketing authorization. Then a second patent with a different scope. So in this case, we're talking veterinary versus human medicine, amongst other limitations. And so if the later patent didn't cover the veterinary marketing authorization, then we could ignore that marketing authorization and say that our new one was the first. That was seen very much as being a revolutionary decision, a very very much introducing a more permissive approach to what would be considered as the first marketing authorization. However, it appears that recent decisions really are challenging Neuron quite strongly, and we'll have a look at those because some of those are quite new. So the first decision which seemed to challenge Neuron is still, well, that was only something like January 2019, so that's only a year and a half old in itself. And that looked at a new formulation of paclitaxel. So again, paclitaxel seems to feature a lot in these and is well known as an active agent for treatment of cancer therapy, and previous marketing authorizations exist for use of paclitaxel in cancer therapy. So this was the same indication, cancer therapy, but this was very much a new formulation. It was particles coated in paclitaxel. And it was accepted by all parties that this was a new formulation and that this formulation provided advantages. It was even accepted that there were significant regulatory hurdles required to get a new marketing authorization for that formulation. And so Abraxas looked at this and said, well, this new formulation doesn't cover, doesn't fall within, well, the patent for this doesn't cover any of the previous products because the patent relates to this new formulation. This new formulation was not known, no previous marketing authorization falls within this. According to Neuron, we ought to be entitled to an SPC to this. The SPC was granted in some countries who took on this Neuron approach really wholesale, but it was refused in others, particularly the UK, and was referred up to the CJEU. And in this case, the CJEU managed to distinguish between the Neuron situation and the Abraxas situation. The Advocate General's opinion was very much more straightforward on this, but the CJEU said, oh, we can talk about formulations and say here, for a new formulation, the first marketing authorization within the basic patent test doesn't really apply. So that started to chip away at Neuron, but wasn't perhaps generally applicable. However, and this case is, it only came out in July, in fact. Those of you who saw the first of these webinars may have noticed that I did say, well, hopefully this decision would be out by the time we got to this episode, if you like. And true enough, it has come out. And the Santen case related to an ophthalmic emulsion containing cyclosporin. Now, cyclosporins, very well known immunosuppressant, previously used for preventing organ rejection and situations like that, and transplant and so forth. And the French Court of Appeal referred a number of questions relating to Neuron up to the CJEU, essentially saying, really, does this apply? Should Neuron be limited to humans versus animals? Should Neuron be limited to where there's a new mechanism of action? Should Neuron be limited to a new therapeutic use? And should that be stricter than second medical use in patents and so forth? So the Santen judgment was much more straightforward in terms of addressing the issues than the Abraxas judgment. So although it doesn't specifically address those questions individually, it does pretty much address them in a fairly straightforward way. And they took a look initially at Article 1B and the question of the product and said, well, this is an active or a mixture. Should the product be dependent on the therapeutic use? And the court said, well, the general understanding of active ingredient, no, that doesn't really permit restriction on a specific use. So they said, well, the SPC protection extends only to the product covered by the marketing authorization. This isn't a limitation to a product for a specific use. So product for a new use is not distinct from the previous product. So we then look at, well, how about this limits of protection of the basic patent issue? So they said, well, look, Neuron had discounted an earlier marketing authorization if it fell outside the scope of the new patent, the one on which the new SPC is to be applied for. And the CJEU said, well, but this would conflict with the definition of product because we can use a second medical use patent as the basis of our SPC. And so we could potentially have two products based on two second medical use patents where those patents didn't overlap, but that would still be the same active agent. It's kind of a circular definition. It's sort of saying, well, the product, we can't have two products because we, that would be two of the same active agent for different therapeutic uses. We can't have two different products for two different therapeutic uses, so we can't have that. So it's kind of saying we can't have this because we can't have this. But nonetheless, it's still a much more straightforward decision. It essentially says, well, look, no, we're going to reject this idea of a further medical use, different scope of patent protection, allowing us to ignore a first marketing authorization, because really there's nothing in the regulation to suggest that the scope of basic patent was relevant to whether this was the case or not. However, from the point of view of second medical use claims, Sandoz does say, well, look, we can perfectly well have the product defined by a second medical use claim. That product can be previously known, but if it wasn't marketed, wasn't an earlier marketing authorization, that doesn't conflict, so we can have that. So there's no negativity there regarding the use of second medical use claims, but it does have to be second medical use claims that exist because of perhaps our academic disclosure of a previous use, or previous use which was never marketed or never marketed in the European Union, for example, and so never had a local marketing authorization. Then we can potentially base on those. But the idea of the marketing authorization for an earlier product being discountable if it falls outside the new basic patent, that seems to be fairly clearly out. So a quick look at one pending referral which currently exists at the CJEU, and frankly I'm not sure that this referral is going anywhere, because this is really based on the idea of, well, Neuron says this for Article 3D, that we can ignore an earlier marketing authorization in some circumstances. Does that mean we can ignore an earlier SPC as well? I suspect now with Sandoz having come along, really the situation here may be much more trivial. So, I think that this case will probably go nowhere. We may not even get a decision on Article 3C, because I suspect they will look at Sandoz and say, no, this falls under 3D in any case. 3C just isn't really worth looking at. If they too decide, I would expect it to be in line with Sandoz. Quick look at one interesting situation that might potentially be something that will be of contention in the future, and that's the question of what is the scope of an SPC. Historically, we have the Pharma case, which sort of said that for small molecules, alternative salts and esters ought to be covered because generic companies shouldn't be able to sidestep an SPC just by using a different form. However, things have moved on. I mean, that was 97. We're 23 years on, and there are many more biological active agents now on the market and being developed, and the situation with variants of those is much more complicated. And so there's much more of a question of what scope will the SPC cover, and also a corresponding issue now is how are we going to define the scope of our SPC, because the SPC regulation doesn't put any emphasis on how the product is defined, and yet here we have a case where that was important. So in this, I assume it's pronounced Pharmac case, we have, well, in fact, we have it set out more clearly on the slide, so let's look at that. This was referred ultimately up to the EFTA court because this originated in Norway. Obviously, Norway doesn't refer to the CJEU, but it does refer up to the EFTA, European Free Trade Area Court. So here we have a patent where an initial viral strain, this related to salmon pancreatic disease, and that was caused by one of several types of viruses. I think there were 5 strains potentially in total. And there was an initial patent based on virus strain 1, which was in fact extracted from one area. One was from Ireland, one was from Norway. I don't remember which way around they were. But there was an initial virus strain which was the subject of a patent. The marketing authorization related to the inactivated version of this virus strain for use as a prophylactic vaccine to vaccinate salmon against this viral pancreatic disease. The Pharmac product, however, was a different viral strain, SV3, and I think that was the one that was extracted in Norway, but in any case it was genetically distinct from the viral strain number 1. And Pharmac said, well, we contend that the SPC doesn't cover viral strain number 3, or if it does, that the SPC should be considered invalid. So the EFTA court, so this went to the Norwegian Court of Appeal, it was referred up to the EFTA court and then back down for a final decision from the Norwegian Appeal Court. And so the EFTA court said, well, the SPC could extend to cover a viral strain that's not specifically mentioned in the marketing authorization, but there are some very stringent criteria required for that. So it needs to be considered the same active ingredient as far as the marketing authorization is concerned. So it needs to be the same active as the approved medical product, and it needs to have effects falling within the same therapeutic indications for which the marketing authorization was granted. And so this same active ingredient puts a very sort of tight limitation on how similar these should be. And in fact, ultimately, the Norwegian Court of Appeal invalidated the SPC in its entirety on the basis that although equivalent variants, as I said, should be covered by the SPC, it shouldn't be seen to impede development of products with greater efficacy. And this viral strain 3 was the subject of evidence that suggested that it was considerably more efficacious. I think that was in the Norwegian salmon population where this viral strain 3 was more prevalent. So perhaps it may have been in some ways related to the fact that this was taking place in Norway that it would show greater efficacy. But in any case, it had advantages, particularly in that population of fish, and the court held that to allow the SPC to cover that would be impeding development of products with greater efficacy. So we really have quite tight limitations still on how variable the biological active can be. And that perhaps is in contrast with Pharmatalia, which seem to feel that, you know, the SPC should cover, you know, foreseeable variants. So it could be, and as you have seen, neither of these cases relates to the CJEU as yet. We have the Norwegian Court of Appeal and the EFTA court, but perhaps this is an area where we need to keep an eye on future developments because there could be case law developing on here, and we need to be careful perhaps about how we define the product in the SPC, because the SPC regulation puts no emphasis on how that definition is made, and yet here we have an issue where the scope of the SPC is considered to be overreaching, covering products that are improvements over the original, and then potentially being invalidated as a result. So that's yet to be supported by any CJEU judgment, but we'll have to see whether that, that line of reasoning does have legs or not. So that's really what I was talking about in this slide, is that we can cover salts and esters. We need to think about the question of biosimilars and how that applies in view of Pharma. And even though the SPC makes no legal requirement for the product definition, we should perhaps be careful of that. Although Justice Arnold in recent just comment, essentially, in the Sandoz case, said, well, the definition is just an administrative exercise. This doesn't really matter. So two schools of thought on that. Whether that will be of contention in the future, well, we will have to wait and see. So finally, to wrap up with some messages on this, what can be protected? Well, medicinal products, not medicinal devices. Boston Scientific tells us that. Give us an idea of what we should be applying for SPCs for. And equally, each therapeutic active must have its own effect. So adjuvants, delivery systems, things like this are probably not going to be considered active agents. So them on their own, or considering them to be one part of a combination product, probably that's not going to fly. Protected by a basic patent, well, TEVA perhaps gives us a better idea of what that means. However, having talked much more about the patent rather than the claims, that perhaps gives us more opportunities, but it does put some emphasis on our drafting and the fact that we need to draft these to make clear that the combination product, potential combination product, is a part of the invention as well as single compounds. So if, for example, there's a group of potential compounds, we need to make it clear that those could be used in combination if that's a conceivable product, because that combination needs to be identifiable as part of the invention. However, hopefully, there's less of a requirement to have that actually in the claims as granted. However, we still need to be able to identify each active agent. We don't know quite how that, how strict that is, but certainly the more specific we can be, really the better as far as the SPC regulation is concerned. Second medical use claims, yes, these seem to be fine. They're endorsed by Sandoz, but the Neuron test, that seems to be on its way out. So we are really looking at second medical use claims fine, but not if you've got those claims because there's a previously authorised product, because the previous marketing authorisation is likely to knock us out there. And scope of protection, well, we need to keep an eye on drafting SPC applications that we don't overreach with the product definition and cover grounds for invalidation, but equally we don't want to unduly limit our product definition. So that's going to be a case-by-case question of really looking at what's likely to be marketed, what's in the marketing authorization, whether any amendments to that are likely, and crafting the SPC product definition more carefully perhaps than we might have done years ago. And so yes, with that in mind, the final take-home message, as always, is it's always changing. So keep an eye on the upcoming cases and on Dehns.com, and hopefully we'll try to keep you up to date. So that is my contact details. And I think we do have some questions. So the first one that I have here is, am I aware of instances where the CJEU has overturned its own earlier judgments, or is Santen effectively overturning Neuron, and is that the first time that this has happened? Well, I'm not aware of situations for this. I have to say, the CJEU obviously makes judgments in all sorts of areas that I don't keep tabs on. In the SPC area, Neuron could have been said to be wildly inconsistent with anything that had previously gone before. That's the closest that I'm aware of it strictly overturning its previous judgments. In fact, there's another question, is Neuron dead? Well, that kind of ties in with this, that yeah, I think Santen is really killing off Neuron, and yeah, Neuron was the closest I'm aware of to having really flown in the face of everything that went before, and now we see where that got them, that actually really Neuron is pretty much dead, has pretty much been overturned because Abraxas sidestepped this. The Advocate General's opinion in Abraxas was really, no, all guns blazing, no holds barred, Neuron is going, is going. But the final judgment in Abraxas kind of sidestepped it and talked about formulations and didn't hit it face on. Santen has not done that. Santen's pretty much straight at it. Neuron has gone. And Neuron was always based really on policy rather than law, and it could be that that policy will swing back again, but I can't see that happening. So no, really Neuron, Neuron seems to be dead, and I'm not aware of anything that overturned a CJEU case quite as directly as Santen now has. So I also have, in the GSK case, had the second SPC for adjuvant and antigen been declared valid? I don't believe it had. I think in both cases, the UK IPO had rejected that, had said that, no, this can't be the product, this can't be a combination either. So yes, from memory, I don't believe that the UK IPO granted an SPC on either of those. And yeah, finally, is TEVA the final word on protected by the basic patent? Maybe. It's very much a lawyer's answer, I'm afraid, but I think we will probably level out at TEVA for the medium term, because we've now had a couple of cases supporting that, well, TEVA itself, and then 1.5 cases in royalty and Sandoz. And, it seems like perhaps the CJEU is getting its act together and trying to, be a bit more consistent about these things. But there's a load of space still for interpretation. We've got fall under the invention, we've got specifically identifiable. It seems very likely that those will be refined a fair bit more before this is all over. It could be that the rate of referrals may go down a bit though, because Brexit will take the UK out of referral up to the CJEU, and so quite a fair proportion of these recent cases, I don't know whether it's half, but certainly a good number of the recent cases have been referred up from the UK courts, and so it could be that the rate of referrals will go down a little bit once the UK courts are no longer referring up to the CJEU. But in my opinion, yeah, TEVA is probably here to stay, but I suspect there will be referrals to refine it, because some of those terms just don't really give us a whole lot more than we had before. So that's all the questions that we have. So thank you very much for all of those. We have more webinars in our series. This is the list, and I will hand over to Michelle to take you over that upcoming list of webinars.